The Proud Boys trial hits a major rub for the prosecutors. Looks like it may have been derailed by two motions, which may have a moderate chance of success given all of the revelations that we have seen relative to the January 6 cases. Today, we're going to talk about two major motions, one from Dominic Pezzola, who filed a motion to dismiss. This came after Tucker Carlson released additional January 6 footage. Of course, we've covered all of that here, but we'll highlight the footage that is being referenced in the motion. They talk about this guy, Kevin McCumber, and it's a spicy motion. Now that we're seeing there's a lot more evidence that apparently the defense never got, we start asking ourselves about very important concepts like Brady materials and like the Jenks Act, which is something that we're going to talk about in detail today, because another motion was filed on behalf of Ethan Nordean, which was another Proud Boy, is another current Proud Boy defendant. He filed a notice of impeachment saying that this FBI agent, a special agent, goes by the name of Nicole Miller. I don't know if this is her. I just got an FBI agent, generic person. And she allegedly, according to Ethan Nordean's defense lawyer, hid a lot of very sensitive information from the defense, and it accidentally got exposed in trial. And it's all related to Jenks material. So we're going to go through all of this. But first, let's understand where we're at in the context. This is the Proud Boys trial. It is day 34. Holy moly. Talk about a long trial. Now, this would be a long trial because we've got 5 different co-defendants. And of course, we know this is the greatest attack on American democracy since the Civil War. So this is what the latest minute entry looks like for March 9th, 2023. See that as of today, here is the minute entry. And we're on day 34 of this trial. And so they are really hoping to wrap this up quickly. We've got 6 different defendants. You see Ethan Nordean, Zachary Real, Enrique Tarrio. We heard a lot about him, covered him at length on this channel. Dominic Pezzola, Joseph Biggs, defendants. Now, they were in court today. The jury panel was not present. They had oral arguments, and we are going to go over to a Twitter thread and read through what happened today, courtesy of Roger Parloff. He's on Twitter at Roger Parloff. So we'll go through those oral arguments. The jury trial was postponed. Okay, so they continued it out until next week on the 13th. That is going to put us on a Monday. And the reason they're doing that is because of all of these motions. Motions to dismiss came in. The judge is like, oh, man, the defense is saying you guys hid evidence from us that was exculpatory. And your special FBI agent is a giant liar on top of it. So the judge goes, oh, crap. Okay, well, we're going to just take the rest of the day off and we're going to come back on Monday and we'll get into it. So the parties who are here, we have a bunch of people who are committed, still incarcerated. We've got Timothy Miller, defense attorneys. The reporter was Timothy Miller. Defense attorneys are going to be Nicholas Smith, Hull, Pattis, Hernandez, Hassan, and others. And who was also there was the FBI special agent, Nicole Miller. Okay, so that was what happened today. Now, I want to show you this Twitter thread, which is from our friend Roger Parloff, and we've covered, he does great work sort of reporting on some of the federal trials. The problem with covering the federal trials is it is not publishable. They can't stream it. They're not going to put it on YouTube. They can't even audio record it. They won't allow you to do anything with any of that material, which is a major bummer. But Roger Parloff is typically there, I believe. And so he live tweets these trials. And so if you want to follow him, I'd encourage you to do that at @rparloff. He is the senior editor over at Lawfare, journalist, published in a bunch of different locations. A great follow. So make sure you give him a follow. Now, this is what he says. All right, everybody. Proud Boys trial, March 9th, day 34. I'm live tweeting this on Lawfare. He says the government's extraordinary grand finale continued yesterday because they were about to end this with their closing arguments and put all these insurrectionists away forever. But it ended snarled in mistrial motions. That's weird. These trials, the reason we have not been covering them is because it's like paint by numbers, color by the numbers, books. It's been very mechanical. The DC judges, we talked about several of them here. One of them was the Steve Bannon trial, but they are just sort of rubber stamping these things, going through the motions. And so we say, holy moly, mistrial motions. What's going on over here? He went through all of that yesterday, but he's going to jump off his thread with this. And so I want to make sure we read this issue. He tells us, the issue that really spawns all of these defense motions was a spreadsheet that was provided to the defense from FBI Agent Nicole Miller. Okay, this is a spreadsheet from her link, which is the FBI system, sort of like an internal communication system. You know, we use Telegram for our community conversations. Businesses use Slack. Others will use Facebook, business or whatever, workplace, Google Chat. This is like the FBI's version of that, right? Link, where they all send messages back and forth. So among others, there was an FBI agent named T. Wang. And so this spreadsheet just came out. And we're going to go through that in a quick minute. You can see what it is. But it's very important we understand what Jenks-related materials are, right? Jenks-related communications. And I want to just pause briefly to go over that, because this is what the U.S. government says about it. Now, this came from the DOJ manual from 2015, right? The Department of Justice, they put out these documents. We got to train all of our prosecutors on how to deal with those defense lawyers. Ugh. And so they have to learn what all of this stuff means. And so I grabbed this from a 2015 manual, I believe. And here's what the DOJ says. All right. Put yourself in the position of a January 6th defendant, right? You're facing these charges. You're asking yourself, what can I get access to? All right, I've been charged with a crime. The government put me in custody. We have no access to any body cameras. We have no access to any Capitol Hill surveillance footage. We're in solitary confinement for 22 hours a day. We can hardly talk to our families. We really have no ability to communicate with anything. So how, if the Constitution says that you've got some procedural rights and some due process rights, how can you possibly defend yourself if you don't have access to the evidence? It would be like if you were charged with a DUI case and they just took your blood and they said, oh my gosh, you were super drunk, man. And you say, well, can I see the evidence, please? And they say, oh, no, it's okay. We don't need to share any of that with you. Well, I need to see that in order for you to convict me. Don't I need to see it? Well, no, you don't really need to see it, right? These are these discovery problems. And if they don't give you that evidence, how can they possibly prosecute you? They can't. And so if there is no blood results, if they lost the blood and they can't disclose the blood, well, they can't convict you of a blood-related crime. And so we ask ourselves, what duties do the government have to disclose information to you? What do they have to give you and what do they not have to give you? You've heard about Brady material. You've heard about exculpatory information. And so there are some things the government absolutely has to give over to the defense. And there's other things like the opposite of that they don't have to give to the defense unless they actually use it. It's sort of like the opposite. So let's go through this. Now, if you're a defendant, this is a government prosecutor, and they've got to navigate through all of these issues. So now we put our hat on the government prosecutor hat. And this is what they get in their instructions. They say, all right, assistant U.S. attorneys in the criminal division must be familiar and fully comply with their discovery obligations under the rules, under the Jenks Act and federal rules of evidence and the Brady cases, right? So you've got a lot of different rules. This stuff is super important. You can win criminal trials by mastering these rules. In addition, they say that U.S. attorneys should also be familiar with obligation imposed by district courts. And this came out of Northern California. So you've got general policies and then you have local rules for the different local courts. But they give us some of these discovery obligations. First, Brady material. We're all very familiar with this. The government disclosure of material that is exculpatory. Government disclosure of material exculpatory and impeachment evidence is part of a constitutional guarantee to a free trial. The law requires the disclosure of this material if it's material to guilt or punishment, right? If the government has access, they have the whole briefcase. If they open up the briefcase and they have something in there that you should probably have, they got to give it to you. If they find somebody else's fingerprints on the murder weapon and you're in custody for the murder and somebody else there's like, well, that's weird. It's called two sets of prints over here. And we got his. I mean, he's already in jail. But we also found this other set of prints on the knife. I mean, I guess. But we already got him. All right. So forget about that. We'll just put that other set of prints. Just forget about that. Right. No, because you got to give that to the defense, but the defense would never even know if that existed. So the government has an obligation to give that out. And if they don't give that out, this case can be dismissed. So they are constitutional obligations. They have to comply with it. Now, there's an opposite side of this. And so if you want to look this stuff up, please feel free to do it. These are some of the things that the government must disclose. Oral statements about interrogation, relevant recorded statements, the defendant's prior record, all of those things, right? A lot of rules surrounding this. And then these are the local rules that you would see out of a local court. So then what this is really going to involve, a lot of this is going to, two things, right? Brady, I think we're a little bit more familiar with. If there's a second set of prints and they don't give them to you, they don't tell you about that, that's a problem. If there's a second batch of videos that show that your client is actually not doing the things that you're alleging in the other videos, well, then you got to disclose those because you can show a different narrative. For example, if you say that Jacob Chansley was racing in to take over the Senate, well, if there's other videos that show that cops were opening the door for him, maybe your conjugation of the narrative, the way that you reframe the narrative is inaccurate. And the defense should have the opportunity, just like that second set of fingerprints, to see the second set of videos to make their arguments that the other person did the thing. So that's Brady. Now, on the other side of that, you got these defense lawyers like yours truly who are sitting around all the time on these fishing expeditions. We're just out there just like, oh, well, you didn't disclose that to us either, did you, Mr. Prosecutor? Guess what? We're going to file a motion to dismiss because you didn't give us what we asked for. And so then we as defense lawyers, the prosecutors say to us all the time, they say, you guys are just on a fishing expedition. You don't have the right to get any of this material. Who do you think you are? And they say to the court, they say, well, Judge, if we give them this, then they're going to ask for this and this and this and this. And then that's going to overburden our prosecutor's office. We're going to be so overworked. We're already government employees. We have a hard time putting our shoes on in the morning. But please make our lives easier, Judge, and don't make us comply with all of these discoveries. So we go back to like the DUI analogy. Right now, if I go and I say, all right, well, I've got questions about what you did with that blood sample, and I want to see what that test machine did, the gas chromatography machine, how that functioned on that one particular run of blood vials on that one day. And they say, well, we might give you information about that one batch run. And I say, well, I've also got questions about the run that you did before that and the run that you did after that, the day before and the day after. And they'll say, well, okay, we'll give you those. And maybe we'll give you those. But if I say, I want all of the data for all of the batches that you ran over the last 6 months, because I want to see if there's been one single error in any of those DUI samples, if I want to comb through those with a fine-tooth comb, right? Most courts are going to say, get the heck out of here, okay? They're going to go, get out of here. You don't need any of that stuff. And that's to sort of stop the defense from going hog wild and demanding everything. So there's this other act called the Jenks Act. And this one is a little bit smaller, you'll see here, than the other bit of information for Brady. So under Jenks, the government must produce the prior statement of a government witness, but after, right? This is key. But after the witness testifies or on direct examination. All right. So we have a situation where a government witness drafts a report and they sign off on it and they rely on the report, but they haven't been called to testify yet. This is just kind of floating around in the government's file. We have this expert witness and they created this thing and the defense is saying, well, I want that. Give me your expert and give me his expert witness report and I want to see everything that's in there. And the government says, well, I haven't even used this at all. I haven't even used this material. We're not even going to use this. We don't even know if we're going to call this expert or anything. And so this rule says, okay, well, the defense can't have it before they talk. But if they talk and if they testify, then the defense can get it after. Okay, this is important because this FBI agent that we're about to hear from, or this motion is going to be involving, she testified. She referenced a batch of text messages, and then that batch of text messages went over to the defense, and the defense then found a problem. Okay, so this is a Jenks Act, Jenks material problem. Federal Rule of Criminal Procedure implements the Jenks Act and sets forward the principles for it. But you see here, it says the government must produce the prior statement of the government witness after the witness testifies on direct exam. Okay, so these are two big, broad buckets of problems we're going to see. Brady material. What does the government have to disclose but didn't? It's going to be in the form of really videos. And Jenks material, which is going to be what the government did actually disclose after the witness testified. That is a giant problem that opens up a whole can of worms. Now, there's also 404B evidence and tons of other stuff here that is, sort of getting into the weeds. But now that we see that, this is what this issue is about. Let's go to the direct motion. So back to the mind map, we can see this is part one of the arguments that are being made in court. After day 34, the defense filed two monster motions asking for dismissals and notifying the court that they're about to impeach the person who just testified yesterday, FBI Agent Nicole Miller. Here's the motion. Filed March 9th in the D.C. Circuit Court, Proud Boys case involving Ethan Nordean as defendant. A defense motion and notice of argument in support of the impeachment of FBI Agent Nicole Miller. Now, they're writing this yesterday. Yesterday, says the defense, government witness Special Agent Nicole Miller from the FBI was cross-examined by the defense. So the government called her to talk about why the Proud Boys are seditious conspirators and why they should be prosecuted. And the defense asked her a bunch of questions. During cross-examination, she testified that she understood her legal duty under the Jenks Act, which we just talked about, to produce written statements relating to her testimony. So they say to her, all right, FBI agent, you're smart, right? You work at the FBI. You know here that when you're done testifying, you have to provide the materials that you're referencing in your testimony. You understand that, don't you? Yes, I do. So the FBI agent, Nicole, she says, yeah, I know that. I acknowledge that. Yeah. And yes, when I produce that material to you, those statements are going to be in the messages that I give over to you. So just like your Slack messages, just like our Telegram messages or your Facebook work messages or your Google chat, the link messaging system is going to contain everything that I just told you, Mr. Defense Attorney. I'm not hiding anything. I'm here under oath. I know I've got to give you those statements. All from the link messaging system, which is what the FBI uses. This is where Bureau employees communicate with one another. So Nicole testified that in order to comply with the rules under Jenks, she compiled her link messages in an Excel spreadsheet, and then she gave that over to the U.S. Attorney's Office. So FBI agent Nicole says, I know I was testifying here today, Mr. Defense Lawyer, and so I've come prepared. In fact, here's a Google sheet of everything I need. It's an Excel spreadsheet. It's all right here. And he says, great, because as soon as you're done here, I'm gonna want to see those messages that you're talking about. And she says, no problem. I'm smarter than you defense lawyers anyways. And she says, here's a thumb drive or something. So the defense attorneys here, and let's just make sure we're given proper attribution on this outstanding motion, to Dave B. Smith, hailing from Alexandria, Virginia, and Nicholas Smith. Don't know if there's a relation, but shout out to the Smiths. They say, okay, well, we were just cross-examining this FBI agent. She says, yeah, here's my messages. It's everything I got. Here it is. But the version, says the defense, the version of Nicole's Excel sheet that she produced to the defense, it contained 25 rows of her messages, which is weird, right? Only 25 messages? Like, that's not that much at all. I mean, look in our Telegram. Every night we wake up in the morning, there's like 600 messages, right? We got an active, vibrant, intelligent community there. And so 25 rows is not that much. So the defense says, okay, well, during cross-examination, Agent Nicole acknowledged that she alone compiled those records. Nobody else helped her with that. She did it herself. She testified that in cross-examination that those messages constituted everything, a total production. All her statements from Link, that she's complying with the rules. And as we know, the discovery tells us that it is a must, right? They must produce it. We also know that discovery violations, when they hide things, according to the Brady rules, they're pretty much material. They have to follow those because those are constitutional obligations. Oh, man. So if they make some pretty serious discovery violations, that might result in a dismissal of a case. Hopefully that doesn't happen for those prosecutors. Now, they say, this is the defense writing. However, those 25 rows? No, not so fast. A close examination of Agent Nicole's sheet revealed over 1,000 hidden Excel rows of messages. Huh. You're kidding me. That's weird. Why would there be 1,000 hidden rows of messages that were hidden of Excel rows? I don't know. Strange. Miller was thus examined as to whether she had withheld from prosecutors those Link messages. Not good. Hey, Nicole, this is your production, 25 messages, and that's all? Yeah, that's everything. Did anybody help you with this? No, you assembled these yourself, is what you're saying. Yes. Government didn't help you. Prosecutors didn't help you. Nope. Your boss, superior eight, nobody helped. Nope. Okay. And this involves everything that you talked about here. There's nothing else in here that you need to disclose to us. This is everything that you have an obligation to provide us according to the federal rules. Yep. So then the defense says we examined her to ask about these messages that were very conveniently hidden. They've got questions about whether the messages contain any of the following. All right, so Nicole, so it sounds like you've got a lot of these messages that are missing. Do any of those messages involve a conspiracy charge about the Proud Boys case, in particular, whether it was justified or not? Do the facts support a conspiracy charge? Did your messages talk about that? We're going to find out. Nicole, did your messages talk about a Telegram user, somebody called Aaron of the Bloody East, who was involved in, quote, planning chats? Who would that be? That wouldn't be like a federal agent who was involved in, quote, planning chats, right? That couldn't be somebody called Aaron of the Bloody East, certainly. You wouldn't have hidden those messages, would you? You wouldn't have hidden messages about inaccurate FBI informant-related information about whether that should be disclosed to the defense, which would be a Brady problem. You weren't talking about inaccurate FBI information in your messages, were you? On your Slack message, FBI secret Slack channel, were you? And Miller said, no. I wasn't answering. No. She's like sweating bullets right now because she's sitting on the stand. Wow, that's weird. Only 25 messages? Are you sure you didn't talk about conspiracy charges? You don't remember any person named Aaron of the Bloody East? And she's like, oh, crap, I'm doomed. Did I delete those rows or did I just hide those rows? Did I send them the right file? Holy crap, I thought I sent them the most recent file, version 10. Did they get version 9? Oh, gosh. And he's just going one by one. She says, no, I didn't do any of that stuff. Negative. But the defense says, but Miller, the FBI agent Nicole, was also cross-examined as to whether Nicole had gained access to the content of attorney-client privileged communications involving defense trial strategy. Holy moly. Okay, so that's great, Nicole. We're really glad that you didn't hide any information about informants, about planning chats, about factually supporting a conspiracy charge. But did you listen into the phone calls between any of the clients and their lawyers? Did you do that? Again, Nicole answered in the negative. Now, however, the defense says, The agent's hidden link messages do contain statements concerning each of those issues. You're kidding me. As to the question about whether agents could make a valid conspiracy out of this case and, quote, not make a fool of themselves, was her language. That's included in the messages. You can see these messages were sent through the FBI Slack system, and these do look like Excel rows here. And so she probably just hid these up, just highlighted all of them and pressed hide. Thought it deleted them or something. That's the FBI. When I tell you they're playing with crayons over there and playing Where's Waldo, searching around for Waldo in photographs and playing with Legos up there, they are. So these were some emails, you know, back and forth from one FBI agent. These are some messages from one FBI agent to another. February 1st, 1806, somebody sent a message. Yes, what a effing idiot. Okay, so W-O-T, right? It's typical FBI vernacular there. Not very sophisticated texters. Yes, what a effing idiot. Somebody says back, it's really good. Yeah, it's the entire MOSD chat. Enrique didn't delete anything. I'm going to send you another one too. Okay, so they're in the chat. Enrique's in there. They probably invited him to a Telegram group or something, and it has all the history enabled. Right, these guys were not insurrectionists, conspiracy theorists, seditionists at all. They were just dudes, and they're being pinned on this thing. So they weren't ultra secretive or anything like that, right? This was all mostly done in the open. He says, I'm going to send you another one too, which actually has Enrique talking about what the plan specifically is. They make mention of Dick Schwetz, whoever that is, on page 15. At least I'm pretty sure it's Dick Schwetz who they're talking about. Another reason I want to get in front of him. So they're just talking about it. You know, they could, again, you're allowed to plan to show up and protest places. You're allowed to have clubs and free assembly with other people. That's allowed in America. You are not supposed to be infiltrated by rotten FBI agents. But they did it anyways. So he says, okay, somebody says, so will this get us over the hurdle of the conspiracy charge? You see how rotten these people are? They know they don't have anything to charge these people with conspiracy with. And so they're begging for it. They're jumping into their chats, whatever the plan is, right? They could be planning to go to a picnic there on the Capitol lawn. And they're going to say, perfect. We got those white supremacists now. Enrique Tarrio's not even white. So this is nuts. And they know that their case is weak, but they're saying, well, will this get us over the hurdle? Because if not, we got to manufacture something else. And they're literally chatting about it. That's how non-obvious the crime is. The crime of the century, so-called, is so non-obvious, they don't even have enough to get over the hurdle. And the FBI agent lied about it. Did you talk about any of that? No, we didn't. You did. And the materials you disclosed hid it. So then another message says, okay, so long as we can actually go after them with conspiracy, and check this out, and not make a fool of ourselves. See that? Yeah, it's too late. You guys should probably take a class on using Microsoft Office. And then maybe you'll avoid lying. Don't do that, all right? It's helpful for us defense attorneys. Fortunately, this was uncovered. Thankfully, it was. Disgusting that it had to be uncovered. And hopefully there's some recourse for it, but we'll see what the judge does about it. So they are talking about being worried about not making a fool of themselves because the conspiracy charge is such a joke. But that wasn't the only thing that was in her messages. There was also an issue about whether somebody who was a co-conspirator called Aaron of the Bloody East, whether he wasn't too involved with the Proud Boys planning chat, which was a subject of Miller's testimony. Okay, so Miller presumably took the stand. This is Nicole, FBI Agent Nicole, and she's up there talking about Aaron of the Bloody East. And she takes the stand. Is any of this going to show up in your Jenks material? Nope, nothing is. Should have. Here it was. She says, I don't see any emails from Aaron past the 6th, even though there are emails as late as yesterday. And listen to these people, these two FBI agents. I also want to know if his house got foreclosed, right? They're just snooping on these guys. I don't think so. He wasn't involved with the planning chat, nor do we know he was down there. I think he had to work. And somebody says, I mean, if we really want to work all the PB members, he's the one to go after, especially his PayPal, his wife's PayPal, and her Venmo account. Go get his wife too, and get her Venmo. These little FBI agents snooping around on people's stuff, just trying to wreck their lives because they disagree with them politically, and they're trying to fit a narrative. Says, just listen to about 7 minutes of yelling, Zach to Amanda, LOL. Not yet. Haven't come across that one. Haha, I'll bring beer. I just got it today. There's a good amount of calls on it. You see what these people are doing? This is the professionalism of the FBI. They're joking around with this stuff. I'm listening to 9 minutes. This is not, I've never been a government prosecutor. Thank the Lord, never would be. But this type of sort of conduct to sort of hide this material, I don't know who hit it, whether the FBI agents hit it or whether the prosecutor hit it, for this to not come out, for all of these people to sort of just be so jokey about this stuff with everything they do. I'll bring beer, as they are trying to create a narrative. They know, they said previously that they don't even think there's enough there for a conspiracy charge. They're debating about how to make it stick so they don't make a fool of themselves. Simultaneously, while they're dunking on his wife's PayPal account, her Venmo account, and his PayPal. They don't even have enough there. But if they want to go after all of them, they're going to get beer and popcorn, and they're going to listen to the calls like, high school kids going through a stash they found, right? It's insane. That's the FBI. Now, the FBI agent Nicole, maybe also, we're going to see, could have lied about this too. No conversation, no admission about whether there was an agent and a request to Agent Miller to go into a CHS report. Look at this. And edit out that the agent was present. So retroactively go back into a confidential human source report and edit out that the agent was present. You see this from this email address, row 11159. And boy, look at all these thousands of messages. So she just thought she did an export, huh? This is B121. Oh no, that's 8122 645 6485. Look at all these rows, man. Okay, so we're now at 11159. N. Miller sends a message in the FBI Slack channel, their link system. It says, you need to go into that confidential human source report you just put out and edit out that I was present. See that? Nicole Miller says, go into the report that you wrote, delete out that I was present. That's what the defense attorney got. They didn't make this row up. This row came out from the FBI, apparently from Nicole Miller. She said under oath that she's the only person who put it in there. Why does she need to edit that out? And why is the FBI so open and brazen that they're sending this stuff out? I mean, unless she wasn't there. Maybe she wasn't there, right? If she actually wasn't there and they put her in there, well, that's obviously wrong. That's factually inaccurate. But I doubt that's the case. Just saying. Now, we also have another question that Nicole presumably hid. The 1776 returns document. They asked her questions about it. There were questions about whether that document could, quote, solidify the conspiracy charge. So a message either to or from Nicole Miller at the FBI sends the 1776 returns document. Okay, so this document that the Proud Boys are probably passing around in their Telegram group or whatever channels they're using. So they say 1776 returns, something like, we're going to take our country back. We're going to get this nation back on the right path or something like that. And these whack job psychopath FBI agents who don't even know how to use Microsoft Office are saying this might solidify the conspiracy charge, looking for anything because they're sharing this document. But they say, but the Capitol building wasn't listed nor circled for, quote, the occupation. That's weird. They say, would that be an issue? Well, yeah. I mean, if you're trying to say that they were creating a conspiracy to insurrect the Capitol and they don't have any preparatory material for that, yeah, that's an issue. But why did you delete that, Nicole? Why didn't you just include all of this honestly and disclose that in your Jenks material to the defense after you testified? Why might that be? Now, the defense continues. They say, Nicole Miller, the FBI agent, her communications with another agent are also included in these messages. We can see them. And it also states that the FBI boss assigned her 338 items of evidence I have to destroy. Nicole Miller's communication has a conversation with another agent who states that her boss said destroy 338 items of evidence. I don't know what that evidence might be. What could it be? The defense says that from the hidden rows in Miller's link spreadsheet, FBI Nicole, it is apparent that the defense has not received all of her Jenks statements in these relevant communications. Right? We talked about a lot of things, and she didn't give us the materials that she's obligated to give us under the federal rules. That is because the individuals with whom Miller, FBI Nicole, exchanged messages can be seen responding to the agent, but her own statements are missing. So, for example, consider the below hidden messages in Miller's link spreadsheet regarding Aaron of the Bloody East. So it's only capturing sort of one side of the conversation. We read those emails, those messages. At 1912, an agent responds to Miller saying, I don't think so, wasn't too involved with the planning chat, but the Miller message to which agent was replying is missing from the production. Wow. So it seems it is necessary, says the defense, and appropriate to cross-examine Miller with messages like these for several reasons. So the defense is now asking, Judge, she's not on the stand anymore. She testified. We asked her all these questions about the materials. She gave us the report after she testified. We got the Jenks material. We went through the spreadsheet. Turns out she's a giant liar. So we would like to bring, or we think she is, allegedly. And so we would like to bring her back onto the stand to cross-examine her again now that we have all of her unhidden rows. Why should we be allowed to do that, Judge? Several reasons. Number one, Miller testified that she had not gained access to the content of attorney-client communications involving a defendant in this case. FBI Nicole further testified that she had not withheld linked messages from prosecutors about the following issues: whether the conspiracy charge was actually factually supported, whether the Telegram user, Aaron, was involved in planning chats, whether inaccurate information should be disclosed to the defense. All of those messages were hidden, and all of those messages impeach her testimony. It shows that she's lying. Extrinsic evidence impeachment as to credibility, says the defense, is always permissible unless it pertains to a collateral matter. So this is going to her credibility. This is not going to the issue as to whether or not the Proud Boys are guilty, right? This evidence of her secret messages, it doesn't necessarily, it's not being used to exonerate or to convict the Proud Boys. It's being used to blast the credibility of everything that this woman has said. So you got to be careful about how you use the evidence. The basic test for determining whether a matter is collateral, and so they give us some rules here. They say the very definition of Jenks material is that it relates to the subject matter as to which the witness has testified. They say, secondly, since Miller has completed her direct testimony, Nordean is entitled to move the court to order the government to produce her statements in the government's possession related to her testimony. We read those rules. The above hidden messages from FBI Nicole suggest that the government does possess unproduced materials from the FBI, but the government cannot now communicate with that witness to confirm the fact that she has not completed her testimony. And no rule bars Nordean from inquiring in cross-examination as to whether the witness made statements that were not produced. It would make little sense. The witness is in the best position to answer the question. So they say, finally, Nordean must be permitted to cross-examine Miller with her hidden messages. This is about the confrontation clause, right? Got a right to confront your accuser. And we have violation of the government attorney-client communications about trial strategy. More rules here. They say, Judge, the privilege here, if you allow this to happen, if you allow them to just jump into our conversations, you might as well just get rid of all attorney-client privilege entirely. Just get rid of it. The privilege would not exist for anything in our justice system. Therefore, Judge, respectfully submitted, your friend David Smith and Nicholas Smith. Great motion. Absolutely love it. Shocking that all of this stuff was so hidden and so revealed that they were able to extract it and bring it to light. So that is the Nordean notice of impeachment. Now that is a little bit more of a technical motion. You can see that Nicole Miller got on there, said a bunch of things. They asked her for evidence backing up her statements. She gave it to them. The evidence she provided exposed a ton of other materials that we would say lied about. She would say, no, I misremembered, or it's not relevant, or whatever. Major issue. Her credibility is in the garbage. And now we're going to see what the judge does about it. But that was just one. Now we have a whole separate filing. And before we get to the filing, I want to refresh our recollection about Jacob Chansley, because Jacob Chansley is referenced in this motion. And we were speculating that as this material became more and more public, as Tucker Carlson started to expose it, what would this do? Was this going to trigger a bunch of post-conviction relief efforts for the people who've already been convicted? Because maybe they didn't get material that they should have gotten. People often think of appeals as you go to trial, you lose, you appeal your case. But what happens if you decide to plead guilty? Right, you go in, you plead guilty. The officer says, I've got you convicted because I've got this evidence against you. And you say, 9 months later, that officer gets indicted for falsifying evidence. And you go, wait a minute. That was the officer in my case. He said I had drugs in my purse. I didn't. I took a plea deal because I was scared to go to prison and I just got probation, so I took it. But now that officer is a liar. I think he lied in my case. Do I have any recourse? I can't appeal it because I took a plea deal, which is what Jacob Chansley did. Is there any other recourse? Is there any other action? And so for Jacob Chansley, we think about petitions for post-conviction relief and other opportunities to try to reopen the case, even though it's a long shot. But that's a separate issue. Now, we also have a current case that it's open right now. This is, of course, the Proud Boys case. But the footage from Tucker Carlson is still relevant to them. I mean, talk about timing. They are in day 34 of their trial. They're about to get convicted on probably a whole slew of different things, but for this lying FBI agent and but for Tucker Carlson releasing the video. Now we get a big juicy motion to dismiss, saying that they failed to disclose Jenks material and exculpatory material. It's like Christmas, man. You can't ask for better timing. And so before we read through the motion, let's familiarize ourselves with what happened one more time, courtesy of Tucker. And this was the clip relating to Jacob Chansley.
Conspiracy theorist dressed in outlandish costume who led the violent insurrection to overthrow American democracy. For these crimes, Chansley was sentenced to nearly 4 years in prison, far more time than many violent criminals now receive. What did Jacob Chansley do to receive this punishment? To this day, there is dispute over how Chansley got into the Capitol building. But according to our review of the internal surveillance video, it is very clear what happened once he got inside. Virtually every moment of his time inside the Capitol was caught on tape. The tapes show that Capitol Police never stopped Jacob Chansley. They helped him. They acted as his tour guides. Here's video of Chansley in the Senate chamber. Capitol Police officers take him to multiple entrances and even try to open locked doors for him. We counted at least 9 officers who were within touching distance of unarmed Jacob Chansley. Not one of them even tried to slow him down. Chansley understood that Capitol Police were his allies. Video shows him giving thanks for them in a prayer on the floor of the Senate. Watch.
Thank you, Heavenly Father, for giving the inspiration needed to these police officers to allow us in this building.
Contrast the reality of what Jacob Chansley did in the Capitol building on January 6th.
So that footage is going to be what triggers this motion. They're saying We never saw any of that. And we need that information in order to make our defense possible. Just like you need knowledge about the second set of fingerprints on the knife, you need knowledge about the second set of videos for your client. And so the defense submitted a beautiful motion. Let's take a look at this one. Filed out of the District of Columbia, the case is against Dominic Pezzola, one of the Proud Boys charged with a slew of crimes from the January 6 riots. This motion submitted March 9th, 11 pages long, and it comes on the heels of the Tucker Carlson release of the new J6 footage. The title of this motion is Defendant Pezzola's Motion for Dismissal with Prejudice. We like that. Or in the alternative, if the judge isn't willing to do this, if the judge isn't willing to slap the government and say, you guys have really breached protocol, you have violated constitutional rights so egregiously that the penalty is it's dismissed with prejudice, meaning it's not coming back. If you're not willing to do that, judge, which is a big ask, right? That's like Super Bowl home run victory, blowout victory. But if you're not willing to do that, in the alternative, we want a mistrial. All right, so we might have to come back and do this all again, but we still want a mistrial on the recent revelations involving Tucker Carlson, involving the associated testimony and the discovery of massive Brady and Jenks violations and violations of due process and the Sixth Amendment. Whew! Love it. Checking all the right boxes. The defense says, Defendant Dominic Pezzola, by his lawyer, Roger Roots and Stephen Metcalf, shout out to Roger and Stephen, hereby move the court for dismissal of the indictment with prejudice, meaning it is not coming back, due to recent revelations on the Tucker Carlson show and associated testimony in this trial on March 2nd. Also, due to Jenks and Brady violations that were revealed on March 8th, which was yesterday, involving Special FBI Agent Nicole, which established that the prosecution has been monitoring attorney-client communications of the defendants, illegal, destroying evidence and doctoring and fabricating evidence involving confidential human sources. Pezzola requests an evidentiary hearing on this one, judge. Remember, we are in day 34 of this trial. The Proud Boys have been going through this for quite a long time. Many of them are still in custody, if not all of them, sitting in court listening to these arguments. And Tucker Carlson just happens to run some new footage and shatters the entire narrative as it currently exists. Pezzola continues, says, during the trial on Thursday, March 2nd, the prosecution in this case presented Mr. Kevin McCumber. Now, Kevin McCumber is the deputy clerk of the House of Representatives, and the government called him out as a witness. That is this guy, if you want to know what he looks like, deputy clerk of the House of Representatives. And so he gets called in almost like a police officer. If you're charged with a DUI, the police officer will come in. No, this is what I observed when I pulled him out of the car. The reason I stopped him, the odor of an intoxicating beverage and all the things. He's brought in to say, well, I run the House of Representatives and, they were insurrecting my Congress. And so they brought him out as a witness and he testified. That's who they're talking about. Now, McCumber is the highest ranking official of Congress to testify in this case. Mr. McCumber was called to testify starting on March 2nd at about 11:45 a.m. McCumber has been employed by the House of Representatives for over 2 decades. Ugh, these bureaucrats, man. He has vast knowledge of congressional politics, and he has watched hundreds of representatives interact in the House chamber. They say McCumber's daily duties include being in the House chamber, where he helps run the proceedings of the House, and he records entries in the official House Journal log. Now, during direct examination, the government calls McCumber up and they say, okay, Mr. McCumber, why don't you walk us through these videos? So McCumber showed the jury the video recordings of both the Senate chamber and the House chamber gaveling into recess on January 6th. So he's the guy in charge of the gavel, the bang in, the opening, the closing. He's monitoring all the things. This is when we're checking in, checking out. And so they say, we have to prove as the government that they interfered with a proceeding. Remember that claim? They obstructed the counting of the votes. They interfered with the execution of democracy. They delayed the counting. It was like by 4 hours, right? They voted that same day. It wasn't even a big deal. And if the police hadn't, sort of let everybody in, waved them in and stood down, maybe there would have been a lot less people in the Capitol building. We have video of that as well. Point being, If they need to prove obstruction, if they need to show that Congress was doing a thing and then Congress could not do a thing, they have to show that, and they have to show that these defendants in this case, in this particular motion, Dominic Pezzola, that he interrupted the thing. If they're being charged with interfering with the process, they actually have to do the thing. So they brought in this witness, McCumber, and he says, look, they were gaveling into recess. They were supposed to be doing a thing, and they had to exit the thing and go to recess. The bell rang. Go have fun, kids. So prosecutors have claimed now that defendant Pezzola and co-defendants caused Congress to go into recess by entering the Capitol on January 6th. Right? We kind of follow the bouncing ball. Like, it's one thing has to cause another thing. If they really did interfere with the counting of the electoral votes, how did that happen? Did they knock on the door? Did they break a window? Did they turn off the electricity? What was the actual interference? They got to make it connect. They can't just, abstractly say there was a raid. We're talking about these specific defendants, not J6 in aggregate. They keep doing that, but they also have to prove it on an individual basis in a court of law, which is where we're getting the actual reality of this stuff. The numbers and the reality of the overbroad exaggeration of this whole thing are coming out in the numbers. Here, several counts of Pezzola's indictment, including counts 2 and 3, they require proof that they actually caused the recess of Congress. Now, during cross-examination, Mr. McCumber was asked about the recess, or quote, the obstruction, right? That's where the obstruction happened. Bang the gavel, insurrection, MAGA Trumpers are coming in here. We got to exit this congressional proceeding, and we are done. Now, during questioning by the lawyers, Mr. McCumber admitted that there was no need for Congress to recess on J6. McCumber testified that protesters have frequently, at least 6 times in his personal experience and observation, demonstrated in the actual chamber and on the floor of the House. That's a fun little fact, isn't it? So 6 times before, other individuals have come into Congress and protested on the floor. At least 6 times. The government's own witness, the person that they called, Mr. McCumber, is stating that in court on the record. McCumber testified that each time the protesters came in, they were removed and Congress continued. Interesting. But what's curious about this is on January 6th, they say no demonstrators ever entered the House chamber at all. They were never even in there at all. They weren't at all? I mean, didn't we see photos of them like just over and over and over? Or was that only the Senate with Jacob Chansley? So they never even went into the House. Now, the defense says for over 2 years, the government has claimed that some of the demonstrators who were in the halls and outside the U.S. Capitol building obstructed an official proceeding in violation of the law. But the government, they say, has steadfastly refused to identify in what way any of these defendants directly caused the recess of the joint session. How did they do it? Did they kick the door in and cause them to, panic or what? Despite repeated demands for disclosure of this information as potentially exculpatory evidence, whose disclosure is required under the law, Brady versus Maryland. So they keep saying that you interrupted Congress. But how? How did that happen? Nobody even entered the House of Representatives. So why did they have to recess out of the House of Representatives? And we saw other cops opening the doors for the Senate and letting Jacob Chansley in. So why did they have to recess? If they voluntarily recessed, that was from a cause of their own, right? They said, we're panicked. We don't know what's going to happen. That doesn't mean that Jacob Chansley caused it. That doesn't mean that Dominic Pezzola in this case caused it. So they say that Mr. McCumber's testimony plainly refutes the government's claim that the defendants caused an obstruction. And even if they were on the floor, they didn't have to enter into recess. In fact, 6 times previously, McCumber, the government's own witness, has said, yeah, there wasn't even anybody. There was no reason to recess. We never did that before. We only did it this time. Why? Because I guess they were Trumpers. Now, but what about the Senate chamber? So the defense makes the argument. They say, look, nobody even entered the House, and they've got to prove that there was actual obstruction with any proceeding. They haven't done that here. They say even if the House could have continued without recess on J6, they say, yeah, but everybody's going to just say, well, what about the Senate? Oh. Evidence in this trial has established that for a brief time, around 2:30 to around 3 p.m., protesters did in fact breach the Senate for about half an hour. Wow. Inspector Lloyd of the Capitol Police testified that a protester managed to leap down onto the lower floor from the balcony, and that protester then opened the door to let him in. Never during this trial, never has there been any evidence of any raucous or extremely disruptive or violent demonstration in the Senate chamber. There have been a few images of demonstrators sitting on chairs and standing in walls, but no violence, they say, raucous, disruptive, or violent demonstration inside the chamber. And I agree with that. Chansley was saying prayers for everybody. But then came, the defense says, the Tucker Carlson show. March 6th comes around 2023. Tucker Carlson released the shocking footage from J6 that showed Jacob Chansley calmly walking through the halls of the Capitol with 2 Capitol Hill police. At one point, one of the officers appears to try opening a door or elevator and then turns and leads Chansley in another direction. Later in the video clips, Chansley is seen walking past 9 police officers gathered in the hallway, and his police escorts walk right past 9 other officers without any resistance at all. And then the Tucker Carlson show, says Dominic Pezzola and his lawyers, they presented footage of officers calmly escorting Chansley into the Senate chamber. Into the chamber. The Washington Post wrote that Albert Watkins, Chansley's lawyer, who I have a clip of coming up, was his lawyer through sentencing, said that he had been provided many hours of video by the prosecutors, but not that video. He said he had not seen footage of Chansley walking through the halls with multiple police officers. He says, "What's deeply troubling," Watkins said, "is the fact that I have to watch Tucker Carlson to find footage that the government has, but chose not to disclose despite the absolute duty to do so, despite being requested to do it in writing multiple times." I have that clip here from Tucker. Let's just jump into that one while we're on it. Here is what he said.
But we have a question, which is how in a free country guided by the Constitution were these people allowed to withhold evidence from Jacob Chansley's lawyer? How could that happen? Albert Watkins represented Jacob Chansley at his trial. He had not seen that video evidence until we broadcast it on Monday, and we're happy to have him join us now. Mr. Watkins, thank you
Jacob Chansley's
for coming
lawyer.
on. If you could just restate clearly, just to make sure that, I don't want to put words in your mouth. Had you seen that clearly exculpatory tape of your client?
Of course not.
At trial?
No. We went through extraordinary efforts on behalf of our client to put him in a position of knowledge. That's my duty.
Now, this is
as an agent.
This is going to be standard defense attorney boilerplate language, so keep that in mind.
Of the court, to make sure that he knew everything that the government had, good and bad, to put him in that position to make a learned, informed, voluntary decision about whether to go to trial or take a plea. And remember, this is a man who had tremendous intelligence, very gentle, very, very articulate, who was diagnosed 15 years earlier by the government with a mental health issue. And the government knew that. The government knew through 3 hearings when we begged and pleaded to get this man out of solitary confinement, literally falling into an abyss mentally. And through each of those 3 hearings, that government assistant U.S. attorney knew the most important aspect of that hearing was that Jake was not violent. The government knew. They knew that Jake had walked around with all of these police officers. They had that video footage. I didn't get it. It wasn't disclosed to me. It wasn't provided to me. I requested it. I filed the requisite pleadings for it. And whether I did or not, they had a duty, an absolute duty, with 0 discretion to provide it to me so that I could share it with my client.
So very simple question.
I didn't like that at all from him. Whether he says I filed the right motions, but whether I did or not, they still had a duty to disclose that. And I agree that they do have a duty to disclose it, but it sort of feels like maybe he didn't file the right motions. He's like, I filed the right motions. But even if I didn't file the right motions, they still should have given it to me anyways.
Walked around with all of these police officers. They had that video footage. I didn't get it. It wasn't disclosed to me. It wasn't provided to me. I requested it. I filed the requisite pleadings for it. And whether I did or not, they had a duty, an absolute duty, with zero discretion to provide it to me.
Now, I haven't looked that up
with
or
my
anything,
client. I never got
very,
it.
very simple question. It's shocking that this could happen and happen with the knowledge of Liz Cheney and Adam Kinzinger and Chuck Schumer and all the ghouls around the story. How can this man still be in prison tonight? He's still in jail tonight, right now.
Well, it's a tragedy. I mean, what's happened is truly a dagger in the heart of our American justice system. We can't allow it. And but for you disclosing it, and whether this isn't about you, this isn't about January 6th. This is about our justice system being so compromised. The very integrity and core of that which we wore as a badge of honor for the entirety of our nation's history has been rendered a vile, disgusting mess by a Department of Justice that was running amok. And they didn't share the video of my client, the footage of my client with 9 officers surrounding him, peacefully wandering about, trying to help him, trying to get him access to the Senate chamber. They didn't, because it didn't fit their narrative. And but for you disclosing it, I don't know where we'd be.
Well,
Well,
my next question for you is, what are you going to do about it? Are you going to file a complaint against the prosecutor? I mean, you're going to file a complaint with the judge? I mean, they totally screwed your client. What do you know?
Why they're attacking you makes no sense at all, because by doing that, they're shrouding in secrecy, or trying to, their own assault on democracy.
Yeah, I mean, it's dogs barking to me. Speaking for myself, I don't care at all. But I feel for this man who I've never met, sitting in jail tonight. I mean, it's really beyond belief.
He's a tremendous, intelligent, peaceful man.
All right. Well, I hope he does something about it, because he was on the case, and he has his case files, he has his notes, he knows what he filed, and if the government didn't actually disclose critical information that might exculpate your client to you, that's a problem. You could file a bar complaint against a prosecutor, file a big slew of motions to reopen that case. We'll see if they do anything about it, but I'm not so sure that they will. Fieldofgreens.com, which is where you can get your real organic superfood, because we would all like to lose some of those leftover pandemic pounds, but we are all sick of the ads for weight loss pills and diet pills and all of that stuff. We've all been there. We've all done that. And we know that they don't work. But you know what does? Eating your daily servings of fruits and vegetables every single day. You do that, and the weight would probably just start falling right off. But look, fruits and vegetables, who's got time to prepare that and eat that every day? You don't have to. Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, very specific fruits and vegetables you're not going to find in any other product. And proper nutrition reboots your metabolism so you burn calories faster and lose weight the healthier way. And Field of Greens is the only brand that's backed by a better health promise. You are going to look healthier and feel healthier, but the greater proof is going to come at your next doctor visit when you show up and they say, "You look amazing." Whatever you're doing, keep it up. And so let's get you started today. Go on over to fieldofgreens.com, get your real organic superfood, save 15% when you check out with code Robert. Don't forget to use code Robert so that you can save. The vegetables want to be eaten. They're disappointed when they just, sit in the cabinet. They want to help you be healthy and nutritious. And so get your real organic superfood, fieldofgreens.com, and don't forget to use code Robert. Going back to Jacob Chansley, I had questions about the number of videos that were included, or that were included at his sentencing. So this is one of the most recent filings in the Jacob Chansley case. On October 13th, Chansley, in his case, this entity called CNN, Broadcasting, all of these other entities asked for permission to get his sentencing video exhibits, okay? When Jacob Chansley, he took a plea deal, and they sentenced him to over 3 years in prison, and they submitted video exhibits, the government did. And this is the motion the government is asking for those, the media is asking for those videos to be released. And what was curious about this when I was reading this is not necessarily that they want the videos, but more that it was 12 videos that were included. And where did I see that? Here it is. With its sentencing memorandum, the government submitted 12 video exhibits called the video exhibits, right? So these are the government video sentencing exhibits. So my point is, what were those videos? And we know videos were included in the sentencing. Why didn't the defense have the opportunity to present their side of the videos? 12 videos. You know, when you sentence somebody to prison, you typically have letters and mitigation and people speak. Jacob Chansley gave this big long talk about how he's changed and all that stuff. The government submitted videos. The defense didn't get any opportunity to submit any videos. And this was just granted, actually. So the defense, the media got their hands on all of those video exhibits. But the highlight reels can be used for sentencing and for escalating the charges, but not so much for mitigating them, I guess is the standard coming out of the DOJ now.